Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have an amazing webinar, a very helpful webinar on a contractors, subcontractors, and suppliers step-by-step guide to getting paid by the incredible Emily Pendleton. So without further ado, I would like to introduce the amazing attorney, Emily.
Good morning, everyone. Happy Friday and happy St. Patrick's Day. I hope you all have your green on today and have a very lucky Friday. So I have a lot to cover today, so let's jump right into it. Let's see. There we go. If you have any questions, please enter them into the text box and I will try to get to them to the extent we have time at the end for any questions. Okay, so you're going to find yourself, stuck in some situations on Texas construction projects where you need to think about situating yourself in the best position possible to avoid having to go to litigation or filing any sort of formal claim in the courts. And so today we're going to cover the options that are available to contractors, subcontractors, suppliers on Texas construction projects in order to mitigate that risk and hopefully get you paid sooner rather than later. And so in order to orient yourself in terms of the rules that are going to apply to protect yourself in those claim situations, you need to evaluate what type of project you're performing work on. And so here's a big picture overview of the types of projects you might find yourself working on. You've got your commercial private projects, which can be bonded or unbonded. You've got your residential private projects, and then you've got your state public and your federal public projects, both of which are required to be bonded by statute. And so today's presentation is primarily going to focus on commercial private construction projects in Texas. And so we're going to be talking about the rules applying to perfecting your lien claim on those commercial private construction projects. That's not to say that if your work primarily consists of performing work on residential projects, the same rules are going to apply in terms of the steps that we go over today, but the deadlines are going to be a little bit different, and that's something I can help you with, Ariella can help you with, but the structure of perfecting your lien claim is going to be the same on the residential side as well, just again, different deadlines. And so again, to kind of set the stage here, there's been numerous changes made to Chapter 53 of the Texas Property Code, which is what sets out the rules to perfect your lien. And so be sure and think about when you're going to apply these rules. We're talking about projects that began January 1st of 2022 or after, and that being the contract between the owner and the general contractor was entered into January 1st of 2022 or after. If you find yourself working on a project that you know began back in 2020, COVID hit, there's been all sorts of delays, supply chain issues, those sorts of things, the old statutes are going to govern. And so there's going to be some different deadlines that might apply to second-tier subcontractors in perfecting your lien rights. And so just be cognizant of that in case you are working on an older project. But for the vast majority, the new lien laws are going to apply going forward, and those are the laws we're going to be covering today. All right, so let's talk about how to perfect your statutory lien. There's 4 steps you're going to need to follow, and we're going to go over each of those steps today. So you're going to need to send your pre-lien notice. This is notice before recording your lien affidavit. Then you're going to need to record your lien affidavit if there's no timely payment in response to your pre-lien notice. And then you're also going to need to send notice after recording your lien affidavit. And if those steps you've taken to perfect your lien don't get you paid, the next and final step you're going to need to take in order to get paid is to go ahead and file suit to foreclose on that lien. All right, so let's go through each of these 4 steps. So the pre-lien notice. So what is the pre-lien notice? This is set out by statute. It's a really simple form, and you can utilize this form, fill it out. Another recommendation I have is to attach your invoices to the pre-lien notice just for further support of the amounts, the work that's been performed and the amounts that are outstanding. All right, so who needs to send the pre-lien notice? Let's, in terms of who needs to send it, it's going to be based on your upstream contractual relationship. So to the extent that you find yourself in contract with the owner, you're not going to be required to send pre-lien notice, but for anybody downstream of the original contractor is going to have to send pre-lien notice. So pre-lien notice mandatory for subcontractors, not required for any original contractors. And that applies even to material suppliers who might find themselves in privity with the owner for some reason or another. Then you're not going to need to send the pre-lien notice. And so these are just the definitions of owner and subcontractor according to the statute, which defines original contractor as anyone who is in direct contract with the owner or the owner's agent. So the entities here highlighted in red are going to be the entities required to send pre-lien notice to perfect your lien claim. Who must receive the pre-lien notice? You're going to need to send by statute the pre-lien notice to the owner and to the general contractor. But my general practice tip is to always go ahead and send these notices to all upstream parties. So to the extent you find yourself, a subcontractor or even, a material supplier to the subcontractor, you're going to want to send your pre-lien notice to everyone up the chain, just to alert all parties of the unpaid amounts that you are seeking. When is the deadline to send the pre-lien notice? So you're going to need to send your pre-lien notice by the 15th day of the 3rd month after the labor materials were provided. That is a hard and fast deadline, and it cannot be missed. All right, so let's go over a quick hypothetical here where you have performed work in April, May, and June. You've completed your work in June, and you have the outstanding amounts for work performed in April, May, and June. When are you going to need to send your pre-lien notice by? You're going to need to send it by the July 15th date because it's the 15th day of the 3rd month after the work was performed. So you performed work in April that has not been paid. You're going to want to send your notice no later than July 15th. But that's not to say you just send the notice for the outstanding April work. You performed work in May and June that is also outstanding. So that July 15th notice should notify both the owner and the general contractor that you performed work in April, May, and June for which you have not received payment. And it's really important to note that the deadline runs from the time at which you either performed the work or delivered the materials to the job site. And that applies to both the commercial context as well as the residential context. The deadlines in which you have to send these pre-lien notices are running from the date that the work was performed and is unpaid, not from the date of the invoice in which remains unpaid. So to the extent you performed the work towards the very end of April and didn't get out your invoice for that work until May, the deadline is going to run from the April dates, not from the date of the invoice. And I see that come up very frequently. And so I just want to make sure that that's very clear, that it runs from when the work was actually performed. So how to send the pre-lien notice. Best practice is going to be to send the pre-lien notice certified mail, return receipt requested. That is because by sending it through the U.S. Postal Service, that is going to be deemed delivered once it's been postmarked, postage paid, properly addressed, those sorts of things. It doesn't matter if the United States Postal Service loses your mail or whatever happens after it's been dropped off at the United States Postal Service, it's deemed delivered. And so I always recommend to clients to make sure and keep a copy of that white receipt, as well as a copy of the return green card if you get it back. In certain circumstances, I haven't received that back, but that white receipt is going to be really important to keep track of, just in case you do end up having to file suit on your lien claim. You can have that receipt showing that it was delivered and postmarked to USPS. A general practice tip, I always send my pre-lien notices also by another method with tracking that's a little faster than certified mail. Sometimes the certified mail can be really slow, and we'll kind of talk about why it matters to get the pre-lien notice in the hands of the owner as quickly as possible. So I always send it either FedEx overnight or UPS with tracking capabilities as well. All right, so you've sent your pre-lien notice and you still have not received any traction from the owner or the general contractor or the first tier subcontractor to get you paid. You're going to need to think about recording your lien affidavit and making sure you comply with the rules required to record the lien affidavit. So the lien affidavit has specific contents that you're going to need to include. I'm sure Ariella has a form. I have a form. We can help you with those. This sets forth what's in the statute that's required to be included in the lien affidavit. I'm not going to go over each and every one of these here today. One of the most difficult things I think some certain clients struggle with is making sure to procure and supply a legally sufficient identification of the property that you're performing work on. An address is typically not sufficient. You're going to need to get the legal description of the property, which can be found in the real property records. And I can help you with that. Ariella's team can help you with that. But that is required to be included in your lien affidavit. When is the deadline to record your lien affidavit? So it's going to need to be recorded by the 15th day of the 4th month after the claimant's work is completed. Okay, so going back to our hypothetical, performing work in April, May, and June, you concluded your work in June, you sent your notice by July 15th that included the outstanding amounts for work performed in April, May, and June. When is your deadline to record your lien affidavit? Well, it's going to be the 15th day of the 4th month after you completed your work. So if you concluded your work in June, the deadline to file the lien affidavit is going to be October 15th. Where do you need to record your lien affidavit? The lien affidavit is going to need to be recorded in the real property records of the county in which the property is located. And that requires some coordination with the county clerk sometimes if the county in which you've performed the project doesn't accept electronic recording of the lien affidavit. Sometimes it requires mailing the lien affidavit in to the county clerk. And so that 15th day of the 4th month deadline is a very strict and hard deadline. all of the deadlines we're talking about today are, there's not much wiggle room on those deadlines. And so making sure you're acting well in advance is always best practice to ensure that you meet these deadlines. All right, so then after you've recorded your affidavit, you're going to need to send notice of the recording. So who do you need to provide notice of your recorded lien to? You're going to need to provide this notice again to the owner and to the general contractor. My general rule of thumb is just to go ahead and let all upstream parties from you know that you've recorded your lien affidavit in the real property records. When is the deadline to send notice of the recorded lien? You're going to need to send this notice within 5 days of recording the lien affidavit. My general rule of thumb is to just go ahead and send this notice on the same date that you record the lien affidavit. Then there's no ambiguity as to whether or not you met your 5-day deadline, and there's really no harm in doing any of these things early. I understand that oftentimes subcontractors, they don't want to sound the alarms until they absolutely have to, but at the same time you don't want to miss these deadlines. And so acting early is there's no harm in acting early, because you can always release your lien claim at any time, but you can't retroactively go back and meet these deadlines. So best rule of thumb is just the same date that you record your lien affidavit, you go ahead and send out your notice alerting the owner that the owner and the general contractor that you've recorded it. And there's no form of this this notice that goes out letting the owner and general contractor know that you've recorded your lien. It can be very simple, just providing basic notice, attaching the recorded lien to the notice, and sending it certified mail. All right, so while we're talking about deadlines, there was a recent amendment to Chapter 53 talking about the calculation of time, that basically, if it specifically states that the last day of the period is Saturday, Sunday, or legal holiday, the period is extended to include the next day that is not a Saturday or Sunday or legal holiday. And so to the extent you find yourself, it is the fifth, you plan to record your lien affidavit on the 15th of the month, and the 15th happens to be Saturday. Well, you shouldn't rely on the calculation of time statute in order to say, well, I had until the following Monday to get my lien affidavit recorded. You should really act early and get it done the Friday beforehand. But just in case there is this statute, and arguably it will extend all of the periods of time to the following Monday or non-legal holiday. In the event that you find that, the fifth day after you recorded your lien affidavit happens to be a Saturday or Sunday, in which case USPS and, FedEx might not be open, that sort of thing. All right, so now we've gone through steps 1 through 3 in order to perfect your lien claim. So what sorts of available claims are you looking at here? To the extent you find yourself below the general contractor, you're going to have a claim for non-payment against the contracting entity, essentially a breach of contract claim. To the extent you don't have a contract, potentially a quantum merit or unjust enrichment claim. But the perfected lien is going to give you a claim directly against the owner, which is going to give you a lot of leverage in trying to get you paid before having to proceed with filing a lawsuit. But the owner's liability is going to be limited, and it's limited to these 2 different types of funds. It's going to be limited to reserved funds and trapped funds. The reserved funds were formerly known as statutory retainage, but due to the 2022 changes to Chapter 53, they are now referred to as reserved funds. So let's go over why these funds matter, because these are what you're going to be able to claim as against the owner. So the reserved fund is the fund that the owner is required by statute to retain from the general contractor throughout the course of the project, and it's equal to 10% of the original contract price. If the project is not complete, then 10% of the value of the work performed. And the owner is required to withhold these funds until 30 days after the original contract is completed. And so this sets out a pot of money intended to benefit subcontractors that have been unpaid on their project. And so in order to perfect your lien claim as against this reserved fund that is being accumulated by the owner throughout the course of the project, you're going to need to send your proper pre-lien notice, and you're also going to need to record your lien affidavit by the 30th day after the project is completed, terminated, or abandoned. And so you might be thinking now, wait a minute, we just went over that I had until the 15th day of the 4th month after I completed my work to record my lien affidavit. That's not always going to be the case when you've performed your work towards the end of the project. So you need to make sure and orient yourself of, when is my scope of work on this project being performed? And that all makes sense because if you tie it back to what the owner's required to withhold in terms of the reserve fund, they're entitled to release those funds within 30 days or no earlier than 30 days of project completion. So you want to make sure you get your lien affidavit recorded no later than 30 days after project completion, because otherwise the owner is going to be entitled to release the reserved funds to the general contractor, which you don't want them to do. And so to the extent you find yourself performing work on projects near the completion of the project, do not wait to send your pre-lien notice or record your lien affidavit, because otherwise the owner could release those funds before confirming that you got paid. And so potentially, you're aware that your scope of work is the final scope of work before doing the punch list and wrapping up the project. You need to think about, do I have 3 months to wait to send my pre-lien notice? Do I have 4 months to wait to record my lien affidavit, or do I need to get it done sooner? Okay, then the other type of funds that the owner is going to be liable for are called trapped funds. And these are the funds that the owner pays out to the general contractor after receiving your pre-lien notice and failing to withhold amount sufficient to satisfy the amount claimed in the pre-lien notice. And so that's why I said, it's really important that you include all amounts in your pre-lien notice that have not been paid, not just the April amounts that you are required, by your deadline to send notice for. You're going to want to include everything that's outstanding. And then the other thought to that is, in order to trap these funds, you have to get your pre-lien notice in the hands of the owner. Otherwise, there's no funds to be trapped. And so that's why I recommended getting your pre-lien notice in the hands of the owner as soon as possible, by FedEx overnight, UPS, something quick, so that the sooner you get it in the hands of the owner, the sooner the owner has to withhold funds to in its next payment to the general contractor. So to the extent the owner has an outstanding invoice to the general contractor that's scheduled for payment, you need to get your pre-lien notice to the owner first before that payment goes out. All right, so now you've recorded your lien affidavit, you've perfected it, you've had discussions with the owner and the general contractor, where's my money? If things haven't gotten resolved, the only option left is to file suit to foreclose. And so when is your deadline to file suit? There's not a ton of time. The latest changes to the statute minimize this from 2 years down to 1 year after the last date that the claimant may file the lien affidavit. And so you're going to need to contact me or another attorney in order to get your claim to foreclose on your lien filed timely. All right, let's see. We're almost out of time, it looks like, but let me briefly go over bonded projects and perfecting your bond claim. So, as I mentioned from the start, private projects can be bonded. It's not required to be bonded. And then public projects are required to be bonded per statute. As a general rule of thumb, you always want to ask and get as much information at the time of contracting when things are great and the relationships are all positive. Get a copy of all relevant bonds from all of your upstream parties at the time of contracting. Occasionally, there might be more than one bond. Ariella and I just had a situation like that. And occasionally, both the general contractor and the primary subcontractor both procure payment bonds for the project. And that's something that, you know, a second-tier subcontractor can assert a claim as against both the subcontractor's bond as well as the general contractor's bond. Okay, so on the private side, there's really no statutory rules or procedures that you have to follow in order to perfect a claim against the bond on the private side. The bond itself may contain very specific information that you need to submit with your bond claim, and as well as timing for submitting your bond claim. So that's why I say you need to get a copy of that bond in order to follow the procedures set forth within the bond. If you don't have a copy of the bond, you just have general information that I think this project is bonded, but I know it's a private project. Go ahead and proceed with your lien procedures to properly perfect your mechanics lien that we talked about. There's no harm in doing that. It might not attach to the property, but you'll still have a perfected bond claim to the extent that you properly perfect your mechanics lien in accordance with the procedures that we talked about. Then you have your public bonded projects, which have very specific notice procedures that you need to follow, similar to asserting your lien claim and perfecting your right to lien. You need to follow the notice procedures. You need to send your notice to the surety identified in the payment bond and to the prime contractor. The notice has to be mailed on or before the 15th day of the third month after the work is performed. So same timing as the lien notice, the pre-lien notice. And then the notice itself, there's no form like we were able to use with the pre-lien notice, but the notice needs to include a sworn statement of account that states that the amount claimed is just and correct, and all just and lawful offsets, payments, and credits known to the affiant have been allowed. And then I know I haven't talked too much about retainage today. That'll be a subject of an upcoming webinar, but you need to include a statement of the retainage that is applicable to the account that has not become due yet, but for work that has been performed within your public bond claim notice. And looks like I am out of time, but I really appreciate y'all joining me today. And I look forward to our upcoming webinars to talk more about what you can do to protect your lien and bond claims.
Emily, you did a really great job. It's such a voluminous amount of information and certain deadlines that have to be adhered to and certain forms that have to be sent if I'm working on a private job versus a public job, and when we need to send those forms. So I think you did a stellar job. So thank you so much. If anyone has any particular questions, you could certainly ask them in the box to your right-hand side. I think a big part of, while we're waiting for people to possibly ask questions, I think a real issue that happens is, hey, look, I'm on this project and I just sent a claim on bond and I haven't been paid, and they sent me this folder or all this information for me to fill out, and I haven't heard back from the bonding company. What do I do? And Emily, if you'd like to shed some light on for the audience on those bonded projects and surety companies, that would be great.
Yeah, sure. So that's a pretty form response that you tend to receive from the surety whenever you, even on both the private and the public side, whenever you submit your bond claim, they tend to have just a generic form response that requests you to go ahead and provide all sorts of information to them regarding the contract, the outstanding amounts, communications that you've had about the claim, all sorts of information. And, you know, I always recommend clients, I'm happy to assist with those responses, but just lay it all out there for the surety. They're going to be working, you know, in your interest to get you paid. And so in order to provide them, you should always provide them with all of the information that you have about the outstanding amounts, about the claim, as expeditiously as possible, because they're just doing their due diligence needed to evaluate their liability in terms of getting you paid. And they're also going to get information from the general contractor as to why you're not getting paid. So potentially you can utilize them as a resource to further understand where's the bottleneck here. Has the funds not been flowed down from the owner to the general contractor, or is the potential, you know, bankruptcy for the general contractor? What's going on that I'm not aware of? Or is there a potential defect claim with my work, or what's the situation here? And so those sorts of things can, you can kind of get some information on through utilizing the surety as a neutral third party in evaluating the claim and determining their liability in the situation.
That's really great. And at the end, I would also like to add that if you're not getting the response that you need, which is, hey, where's basically my money? At that point, you don't want to delay getting paid. So at that point, and you certainly, again, do not want to, they're not going to be your friend at a certain point if they don't pay you. So you definitely want to sue against the bond. You don't foreclose on it, you would sue against it. And that's where Emily and her firm would come in and assisting you, because at the end of the day, they may delay something and you may very well lose your bond claim rights during the process of back and forth information. So just be cautious there. But Emily, you did such a sensational job. I know we're definitely past our time here. And we could skip to the next slides with our next webinar so everyone can sign up and stay educated. What happens after I file my lien? How do I get paid on June 9th? And then protecting your rights to retainage through liens and bonds. And that's it. So again, if anyone has any questions, please feel free to reach out to us at any time. We're so happy to work with Emily and her firm. They're just sensational. And again, the next slides are contact information. If you have any questions, please reach out to Emily or to me at any time. And yeah, happy St. Patrick's Day. Have an incredible weekend, everyone. And Emily, thank you once again for such a great webinar.
Thank you all.